there. When you're done, come back down here. Don't forget to come back. If you don't come back, I'm going to issue a warrant. Go take care of yourself upstairs and come back.
One eternity later.
Are you ready?
Yes, sir.
All right. So today is September 11th, 2024. It's approximately 12:25 p.m. We are now in Court 5. In front of me, I have Eaton Emitum, case number 2522688. Would you please identify yourself for purpose of the record?
The man Eaton Emitum.
Would you please raise your right hand? Do you solemnly swear to tell the truth, and nothing but the truth, so help you God? That you're going to tell the truth. That's it. Yes? Okay. State, would you identify? Okay. So the reason that we're putting this on the record now is Mr. Emitum has been charged with the offense of unlawful carrying of a weapon. The case is 40 days old. It appears that probable cause has already been found. I don't know if I did probable cause on this, or if I don't know if another judge did, because I don't remember Mr. Emitum, and I was out a week.
It was another judge, sir.
Yeah, lollygagging. So let's just do it first.
On August 2nd, 2024, officers observed a car without a front license plate, change lanes without a signal, and have expired registration as of March 2023. Upon approaching, officers smelled marijuana. PC search returned 4.17 grams and a loaded Smith & Wesson handgun. Additionally, there was a backpack with 3 checks that did not belong to him. Officer called Kumamoto, who said the checks were stolen from her restaurant on July 8th. When defendant broke the front window, went to the back where the checks were kept in the office, broke the hinge of the back door, and exited.
So as a result, because of that, he was charged with felony fraud on that one, on the check. Okay. Yes, he has an open case in the 182nd. Looks like he made a $15,000 bond. With us, I am going to find there's probable cause to go forward. Well, hold on a second. We'll get there. I'll let you say peace, but do you have a Texas driver license?
I think you got private property number with the FMCSA. With my vehicle was on there. It was sticker tags, everything for my business, the Emitum Estates. That's with the Department of Transportation.
Is that from the state of Texas or from where?
This is federal. This is with the Department of Transportation.
Okay, but you still need a Texas driver license, and you need registration.
And here we go. Federal paperwork, private property claims, and registration arguments. This type of discussion has appeared in many court proceedings over the years, particularly in cases involving sovereign citizen-style legal theories. Courts generally evaluate these claims against existing statutes, case law, and established legal procedures. Arguments involving federal registrations or private status do not automatically override state motor vehicle requirements, and judges often focus on whether a claim has a recognized legal basis rather than where the idea originated. You can almost sense the judge shifting into procedural mode here, moving the conversation away from broad theories and back toward the specific legal issues actually before the court.
And I did all my steps with them because of private property that I had. They said if I didn't need to get registration with the state of Texas because I registered. And they said that would be my volunteer, but since it's private property, I wouldn't have to register it.
Okay. From what I know of the law, you need a Texas driver license to be able to drive.
This is what's this case being tried on? That's what I'm trying to, because I kind of don't know what it's being tried on.
It's
criminal,
yeah. Right. In jail time, right?
I believe so.
Weren't you taken to jail?
Yeah.
So that wouldn't lead you to believe it's criminal, right?
Yeah, but under common law, or is it military and tribunal? Because also with
I've been waiting for something like this for so long. This is so much fun.
I'm just trying to see what I'm being tried on, because what I was told with the U.S. side, I had to register it with the state of Texas, with the registration or licensing. I do have my own place with that vehicle too as well. So
you need a license to drive, a Texas driver license. That's it. You either have one or you don't. The federal government has regulated to the states through the Constitution that they have allowed the states on their own initiative to create laws regarding driving on highways and byways. So that's why you see every single state has different requirements for licensing. It's a privilege. It's not a right. right? There's a big difference between a privilege versus a right. You have the right to walk.
I have the right to travel, don't I?
Yeah, taking your happy-go-lucky feet. You want to travel? Take those 2 feet to travel, not in a car.
Just what the 14th Amendment was saying, like I have the right to travel.
You do. Yes, and you can walk your happy ass from one part to the other part. Not in a car, though. Not without a license and insurance.
Was on there from what I did this with the Department of Transportation. They said automobiles were on there, carrier, bicycles.
They're wrong. I'm just telling you now, they're wrong. Whoever told you that, whoever, where you got that, it's complete. Because imagine this, Mr. Emitom, and I've seen this before. Imagine that you get into an accident, right? And you kill a 5-year-old kid. What's going to happen at that point? Whoever owns that car, the other people, they're going to come after you. They're not going to go after they're going to come after you. The first thing they're going to do is, do you have insurance? And if you don't have insurance, they're going to sue you. And then they're going to attach a lien on absolutely everything that you own to satisfy the judgment they get against you. And they will take your house, they will take your car, they will take your bank account, they will attach to where if you ever want to start working and get a paycheck, they're going to garnish all that money. You have insurance, liability insurance, so that if you ever get into an accident, you don't mean to do it. You didn't mean the kid. It's not an purposement. It was an accident. It's happened. You might be looking at your phone. You're looking at, this pretty girl that's walking across the street, and then boom, you have insurance so that if that happens, the insurance company will pay on your behalf so you don't have to pay out of your own pocket. And they will even give you a lawyer to represent you on your behalf because that's what you pay for when you get insurance. If you get into an accident, lawyers usually call you and say, hey, man, tell me what happened. Was it your fault? Or was it the other people's fault? Because we want to know who to pay. And that's why for $30 to $40 a month, you get insurance for that very purpose. And I've seen people come here, they have killed someone, and they get a $250,000 judgment against them. I've seen it. And God, you'll never dig yourself out of that. So the conveying, the this, that, you need a license. You've got to have insurance. And we do it with every single person that comes here.
Can I say for the unlawful carry, the possession of marijuana, the person that was in the vehicle told the officer it was legal hemp that they got from the store. They have receipts and everything in Texas. You can have legal hemp. They got it from the store. Even told the officer it was theirs. He pulled me out the car. He didn't ask for any paperwork. Now you're making the apples right. Now we got to test it. Is it weed? Oh yeah,
is it hemp? Understand that takes time, but you also need a lawyer to represent you.
I found my own discovery. I was representing myself pro se.
And you can do that if you want.
Yeah.
But we have to go through a series of questions.
I represented myself plenty of times. I had dismissals here from
Remember, and for purposes of the record, so Mr. Emitom had a case with me here. It was actually June 7th of 2022. He was charged with another gun case, and that was with Victoriano. God, that was a TA too. And I found no probable cause in that case, right? So you didn't represent yourself in that case. I found no probable cause and they dismissed it. They didn't have to dismiss it, but they did dismiss it. So other than that case, have you ever represented yourself?
Yeah, many times. I have dismissals all through different areas, kind of traffic violations.
You're welcome to do it, who's one of the worst, who's one of the best presidents that in history that you think about right now?
To me, right now.
You can't think of one good president that we've ever had?
I don't know any.
Abraham Lincoln, he wasn't good?
I never met him. I don't know about him at that time.
Abraham Lincoln said something. He goes, you know what? He who represents himself has a fool for a client. That's what he said. Meaning that when you represent yourself, there is an inherent conflict and there's an inherent bias, and you may not be able to see things objectively.
This feels like an important turning point in the hearing. The Abraham Lincoln quote isn't just courtroom folklore, it's often used as a caution about the challenges of self-representation. When people represent themselves, maintaining objectivity can become difficult. Legal proceedings are personal by nature, and without some distance from the case, rulings and arguments can start to feel like personal attacks rather than procedural decisions. The judge appears to be emphasizing a broader point. confidence by itself is not the same as legal preparation or courtroom experience. Knowing how to present arguments, follow procedure, and understand the law involves a separate set of skills.
Do you understand? You also have to comply with the same appellate procedures if you lose, meaning that if you want to appeal for one reason or the other, you have to understand the guidelines and the timing, and you have to comply with those rules as well. Do you understand? You will not be granted any special consideration because of your lack of formal training. Do you understand this? You may fail to properly raise points of error in the trial record if we go to trial, meaning that if we go to trial and you object to something, because that's you hear that a lot, right? This shouldn't be in there. You have to object properly. You can't just say object. There has to be more to it. You have to state the reason for the objection. It has to be a legal reason. You can't just say, I object, and expect me to hold something out. You have to give the legal reason. And there's a proper method that you have to state and ask me to do things for it to be recognized on appeal. And if you don't know this, you cannot at a later date complain. Well, I didn't know that. You understand? You still don't want a lawyer. I will give you a free lawyer. This voluntarily, knowingly, and intelligently made. No one's forcing you to do this. Okay? Knowing all this, are you sure that you still want to represent yourself? I got to tell you, I think that you look like a great guy. You look like you're upstanding. I have no problems that you represent yourself. Understand that you need to be careful what you tell them, though. Everything that you say, even if you think you're hurting yourself by admitting one thing or the other, you could be hindering your case, meaning hurting your case, even if you think you're helping yourself. Do you understand? I'll make you a deal. If at any time you want a lawyer, all you got to do is ask and I'll give you one. Really. If you ever feel like you're under the gun, that you feel like someone's taking advantage of you, I'm happy to give you a lawyer at any time. I want you to understand now, as a condition of your bond, though, I'm ordering you not to drive until you have a Texas driver license and a liability insurance. I'm ordering you not to drive. And I'm going to have you sign with me today an affidavit promising me you're not going to drive. If I find that you drive, I'm going to put you in jail. Do you understand?
I have personals.
Okay. You are not allowed to get into the driver's seat of a car and drive, convey, travel, however you want to term it. You cannot do that. And if I find that you do that, I'm going to put you in jail. And I'm going to make your bond so high, your head's going to spontaneously combust. Do you understand?
That way from my rights to anything?
No, but I'm telling you that you can't drive, convey, get into the seat of a car. If you do, you're going to go to jail because I will revoke your bond. You understand? The only conditions I'm putting on you now are 3. No weapons, no picking up new cases, and don't get into the driver's seat of a car and drive, convey, travel. Are there any other adjectives that you can think of?
Sure there are, but
I guess I'll put etc. so that it tries to cover any type of wording, so to speak. All right. So, Mr. Ematom, I'm going to find that you are okay to represent yourself. We need you to sign a form that you're going to do that.
Even if I don't consent to any of these charges, because I do have my paperwork, I do have.
If you don't consent, just go. If you don't think we have jurisdiction, look, if I didn't think anyone had jurisdiction over me, do you think I would be here? If I was in your shoes? Hell no, man. If I didn't think that someone didn't have jurisdiction over me to be anywhere, I'm not going there. I'm not going to get out, take a shower, put my clothes on, because I like to be naked, right? You know, I'm not doing anything like that. So if you don't think we have it, just go. Otherwise, you're here. You know we do, right? Because if you...
I don't know. That's why I followed.
Let me ask you this. If you just took off now, what would happen? There you go. What does that warrant mean? What does it mean?
What do you mean as far as like the warrant?
As far as jurisdiction is concerned. Do you think that an officer is going to go out and actually pick someone up if they didn't think they had jurisdiction to do it? Do you know how much trouble they would get in? Do you know if Stephen went out there and arrested someone now just for shits and giggles, do you know how much trouble he would get in? Right? If he had no reason to do it, do you know how much trouble he would get in? Right. A lot. He'd lose his job. He'd probably get sued. Right. Can't claim immunity. He'd be toast, Swiss cheese. So that's what I'm saying. If you didn't really think that we didn't have jurisdiction, then go.
I had to take care of this matter
Because you know we have jurisdiction.
No, because I was going to go to 515 Rusk and file my civil lawsuit with the officer to arrest me because they did some unlawful, unconstitutional things that they did to me at that time. So I was going to take it there. You know, I didn't believe they had jurisdiction over me.
I would wait to see how this case goes first before you do that. You know, see how the case goes first before you start jumping the gun.
Like that's what I was waiting.
You know, but ultimately, you know, if I didn't think anyone had jurisdiction over me, I'm not going to go there, man. I have enough important things to do in my life as it is. I mean, you've been sitting here since 8:30 in the morning, where it's now nearly 1 o'clock. You know what I mean? Really. Let's get this thing done. That way you can move on with your life. We can move on with our life and just everybody be happy. That's what it's about. All we want to do is protect our city. That's all we want to do, you know, and I'm going to do it at all costs. That's it. All right. I'm going to have you sign this affidavit. After that, we'll get you out of here. And so, Mr. Emitom, you are going to have to make a plan to meet with Mr. Petrov here so that you guys can exchange evidence. He is our chief DA here. The evidence that's going to present it to you. You can either do it here in court with us, or you can meet with them at their office, because you're going to have to get the evidence to look at it regardless. I'm happy to take any motions that you have now, and I can look at them, and then we can come back at a later date and I can roll on it for you. I see that you have a bunch of papers. I'm happy to take anything that you have, and I'll take a look over it. You know,
the clerk, last month.
do you see anything? Which clerk file it?
I have it right here. The copy. It was with Marilyn Burgess.
Is that for us? Right? We would still get it then, right? Or no? You filed it under this case number or the felony court case number?
No, I filed it for this one on August 9th. I have this case number on there. 2522688.
Yeah, that's it. Oh, no, I don't see anything. Oh, wait a second. I see a motion for discovery. Is that it? It's a motion for discovery?
Yes.
Is that the only one that you've done?
So far.
Okay. I have to talk to officers and back. If you give me 5 minutes, let me take a look at it. And then I'm going to give you a copy so that you can look at it as well. Let me print it out. Pavel, get it out for you if you want to just take a look at it real quick. No, I need him to swear to this, please.
Okay.
Now we shift from philosophy to procedure. Discovery is one of the most important stages of a case because it is where both sides obtain and review information that may affect how the case develops, but there's an important point here. Discovery operates within rules, deadlines, and defined limits. Parties generally cannot request unlimited information without a clear connection to the issues being litigated. Courts usually expect requests to be specific and relevant because the legal system balances access to information with practical limits on time, resources, and scope. The process is designed to gather material that matters to the case, not to become an unrestricted search for anything that might turn up. School. This is where expectations often collide with the practical reality of the system. Evidence collection and review can take time, especially in larger jurisdictions where labs, body camera footage, dash camera footage, reports, and chain of custody procedures all move through established processes and often substantial workloads. Judges are frequently balancing competing interests, moving cases forward efficiently while making sure the information being relied upon is complete and reliable. Speed matters, but accuracy and procedural fairness are central to the process. Criminal procedure rarely works on a fast-forward timeline. Evidence often has to be collected, processed, disclosed, and reviewed before a case can move to the next stage in a meaningful way.